Smells, are you here for Mr. 10?
It's actually Mr. Moran's case, but I graciously agreed to uncover today. So.
Okay. Okay, so Mr. 10 appears here today with Mr. Smells, and we have Ms. Ramon here on behalf of the people. We're set for sentencing. Is everybody prepared to move forward?
The people are ready.
Because of my public defender, he just told me to go for it.
Well, here's the thing. They never go check his plea today, so she's set up for trial.
Yeah.
Morning, Your Honor. We're ready to proceed.
Okay. Ms. Ramon, why don't I start with you?
Absolutely. In this case, Mr. 10 pled guilty to DUI. This would be as a first offense. This would be subject to 12 months of supervised probation and alcohol evaluation and treatment, 48 hours of useful public service. I will note that the PSI noted a prior DUI. This was not a conviction. This was a successful deferred judgment on sentence from case 23 and 5053. I would ask the court to sentence according to the plea agreement, no objection to the other recommendations from probation with a level 2 education, level 2 track D therapy, the victim impact panel, defensive driving course, random BA, UA, and ETG testing. In this case, there is no cost of prosecution and there is no restitution.
Okay. Mr. Smells.
Court's got hesitations about another deferred judgment. I think
deferred
Mr.
judgment.
10's also got some misgivings about this plea, and we might be in a position where we have to withdraw, but I'm curious where the court's at this point.
I was even driving.
Hey,
nothing.
no.
So,
I would note that this is not a deferred judgment on sentence agreement. It's an agreement to probationary sentence.
Okay. Well, I mean, I don't, the plea's been entered into, and I don't see that this is contemplated as a deferred judgment and sentence. So,
And we would reject withdrawing the plea. He was advised and entered the plea knowingly.
Mr. Smells, anything more?
My client's telling me he's innocent and that he doesn't want to do this, so I think that's where we're at right now.
The people would object.
Well, I mean, Mr. 10 did enter the plea. I advised him as to the plea. I mean, I don't know that there's any legal grounds to withdraw from the plea. Do you have any legal authority, Mr. Schmelz, that you want to point to?
I think for me to make that argument would require me to argue against the effectiveness of a member of my office and would create a conflict of interest for me. So I think at this point, it makes sense to set this out and appoint an attorney to advise Mr. 10 about his options for withdrawing the plea. I mean, you can go and sentence him now, but we're just going to wind up back here on a 35C from what I'm hearing anyway.
What's the people's position?
And we would object to setting this out. Again, Mr. 10 agreed to the plea, signed the plea, was advised of the plea, and did so knowingly and voluntarily. I don't understand why we're at this position now.
But the problem is my client's raising a pretty serious issue of constitutional concerns that goes to his Sixth Amendment rights. I'm not in a position to argue that given the conflict. And so I think Mr. 10 is entitled to advise him about that. We can go through it today. We can force this through, just process it, right? But it seems to me that if we do that, Mr. 10's alleging things that would be grounds for post-conviction relief.
Well,
Strikes me as a less efficient way of going through it.
you know what? Here's ultimately, I guess, the way I look at this. If Mr. 10 wants to try to get out of this plea or withdraw this plea, there's a process that he can follow. If he decides he doesn't want to do that and he wants to connect with the treatment providers and move through this, that is also an option. And I think that the advantage of moving forward with sentencing today is it gives Mr. 10 both options. Gives him time to think about it. If he wants to connect with the treatment provider
Your Honor,
he
once
could
he's
do that.
sentenced, the conviction's final. There is no option. I'm not really sure what the court's referring to at that point,
Well, there's post-conviction relief, Mr. Schmelz.
which is exactly what I'm asking for now. For a
Well-
lawyer to advise him about the facts that he's alleging to me that I can't do anything about because it's my office.
Your Honor, at this point, the conviction is a final. If Mr. 10 wants to enter a 35C after his sentence is completed, that's his option.
And which is an option that has far more barriers. We're just railroading this guy. That's what it seems like to me, and I'm objecting.
Well, I'm going to overrule the objection because I think that ultimately Mr. 10, this gives Mr. 10 options. And if Mr. 10 wants to report to probation and go through that process, that's an option for him. And if he doesn't, then he's got other options. And I think that at least presents Mr. 10 with an option for treatment. He decides that he doesn't want to go down that road, then certainly he absolutely has legal rights and remedies that he can pursue. And so I think it's what makes the most sense at this point in time. So I will sentence Mr. 10 in accordance with the recommendations set forth in the alcohol evaluation. Although the recommendations in the evaluation are commensurate with they don't align with the plea, and they're not commensurate with the first DUI.
And that is, again, as I mentioned, Your Honor, the PSI mentions a prior conviction. That is incorrect. That was a successful DJS.
Well, yeah, exactly. That's what I'm saying. So we need to
The
Yeah.
PSI won't change that.
we need to get sentencing recommendations that are in line with a first rather than a second.
I'm not. Yeah, I'm sorry. And Your Honor, we can just go based on the entered plea. We don't have to follow that PSI. We can.
Yeah, that's what I'm saying.
Yeah,
Yeah.
I agree.
Yeah.
Okay.
Okay. So, Mr. 10, I'm going to sentence you to 12 months of supervised probation. You'll be ordered to complete level 2 education in the amount of 24 hours. Outpatient track B therapy in the amount of 52 hours. You'll be ordered to complete a victim impact panel, engage in random BA, ETG, and UA testing. You shall refrain from the use of alcohol, recreational marijuana, or illegal substances during the term of your sentence. You're to complete 48 hours of useful public service. You're to engage in treatment within 15 days of your sentencing. I will order that you report to probation today. I understand that you may be asking for some post-conviction relief. You can certainly, we have a self-help litigant coordinator that you can talk to, and they can at least guide you through that process. If you don't feel comfortable moving forward, that is an option available to you. Your other option, as I said, is to check in with probation and get signed up and get started. So either one of those options are available. Again, I'll just make the record that the plea was previously entered. I found that it was entered knowingly, willingly, and intelligently. And so you've got kind of an array of options at this point, Mr. 10, and really up to you to decide which direction you want to go. I appreciate you being here today. I appreciate your patience. I know it took a while, and so wish you the best of luck moving forward. Okay. So I'm going to call case number 2025 M626, 2025 M674, 2026 M5027, 2026 M260, 2025 M626, 2025 M687, 2026 M77. These are all people of the state of Colorado versus Travis Lopez. I'm sorry, Travis Lopez. Okay, so Mr. Lopez is here with Ms. Bernhardt, and we have Mr. Reed here, and it looks like we've got a lot of plea paperwork. So, Ms. Bernhardt, if you want to bring that up whenever you're ready. Sure. Okay, so I'll try to organize it here. Um,
Cops came and harassed me too.
So just so I'm sure, I should be looking at plea paperwork for 3 cases, correct?
Correct, Your Honor.
Okay. Okay. And so before we move forward with the plea agreements, I guess I've got a couple questions. First of all, I see that there's the requirement for the 9 months of supervised probation. And is that going to give Mr. Lopez enough time to?
They are consecutive to each other. So there's 2 cases with 9 months each. So it's 18 total.
And so the parties don't see that there may be a problem. I mean, for instance, if I impose domestic violence treatment in both cases, Mr. Lopez isn't going to be able to complete within 9 months. And so I don't know if there's a mechanism that probation can terminate probation as you see the problem.
I understand the concern. I know the defense had a concern that violation of protection orders, their reading of the statute is they had to be served consecutive to each other. Not sure that I agree with that, but this was my workaround for that.
Okay.
I believe we could have 2 concurrent 18-month sentences, but I don't think defense agrees with that. So this was our workaround to make sure you had 18 months of probation.
Yeah, I understand the intent. I'm just worried this is going to get Mr. Lopez crossways because he's not going to be able to complete the treatment within 9 months. And so we're going to be at a situation where the first 9 month
Gets
ends
continued.
and we're not done. And so we're going to be kicking that off anyway. They're going to ask for an extension right out of the gate.
Right, which from my perspective is kind of 6 of one and a half dozen of the other. I think it works out the same. Other than we have that additional step of asking for the extension.
Okay. Ms. Bernhardt?
I guess, yes, Your Honor, it's my understanding that the domestic violence course could just be assigned once. And then we could,
See where we're at.
and then he would only have to do it within that 18 months supervised probation if the 2 were to run concurrent.
Yeah, I have a feeling that's going to hang us up because I think what's going to end up happening is we're going to come up to the first 9 month period and the terms and conditions of that probation aren't going to be complete. And so what they're ultimately going to do is they're going to ask to extend. I mean, that's what's going to happen. And I just want everybody to understand because we can't terminate probation as successful if the DV treatment's not complete. Even if there's a second case. I mean, if he's ordered to do domestic violence treatment, complete the domestic violence treatment, then he's got to complete that for probation to be terminated as successful. And so, I mean, we can do it this way, but I mean, I'm just being real frank with you. I think the ultimate result's going to be that Mr. Lopez is going to be on probation for 18 months. So, we can move forward if that's what the parties want to do, but I mean, I think that's where we're going to end up. So.
Yeah, sure. I mean, and then I understand where you're coming from.
And Your Honor, I just let the court know, I'm ambivalent if it's 2 18-month that run concurrent or 9 months that run consecutive. Again, I think it works out the same at the end. There's one extra step that is pretty minor.
I mean, typically what we would see would be 2 concurrent 18-month sentences, but if you guys agree to 9 and you want to agree to 9, I'll move forward with the 9. I just want Mr. Lopez to understand that, it's going to be it's going to take longer than 9 months to complete the domestic violence treatment.
And yes, Your Honor, we're okay with 2 18-month concurrent sentences, but it is our understanding that he would only be required to complete the domestic violence treatment once throughout that. Like it would be the same.
Well, so I don't know what the domestic violence treatment provider is going to recommend. I mean, there's going to be an evaluation. The domestic violence treatment provider is going to recommend treatment, and what those treatment recommendations are, what Mr. Lopez is going to have to do. And if it ends up being 18 months, and it ends up being 18
Right.
months, if it ends up
Nothing
being
in this plea
longer-
agreement should be construed to suggest that the people are suggesting he has to complete domestic violence treatment twice. He has to complete whatever the treatment provider
whatever the treatment
suggests.
provider says.
Yes,
And
Your
so
Honor.
the treatment provider might look at this and see multiple cases and recommend a longer period of treatment than if the domestic violence treatment provider just saw one case. I don't know. I'm not a domestic violence treatment provider. I don't know what they're going to recommend, but I mean, I think that it's all fair game. I mean, I think that they're going to look at the totality of the circumstances and they're going to make recommendations, and Mr. Lopez is going to have to follow those. Any issue with that?
No, Your Honor. I mean, so long as we don't have any issue with the 2 cases running concurrently. So long as the ultimate sentence would be the 18 months of probation.
Do you guys mind making the adjustment to the plea and initialing if that's what we're going to do? Sorry, I feel like I'm throwing a monkey wrench in this, but
Again, I think it ends up working out the same, and I am good either way.
I'm unopposed to, just so the record's clean, making that alteration.
let's do it.
Okay.
Yeah. I'm willing to do whatever it takes. Get this done and over with, Your Honor, but
Let's just show you can cross that out there. They were all consecutive. That was just showing what order. There's another. So you got this one, choose this one. So you do the rest of it.
got a haircut there, Dutch.
I did.
Last time it was long and now it's all cut.
Yep.
Feels better, huh? Too hot out there.
It's a
Yes,
little bit cooler for sure.
Hey, it's getting up to 100 degrees out there, though. They say on the TV. It's getting pretty warm. All them fires out there. Wish I was fighting those instead of in jail.
Do you still have 260, Your Honor?
There, yep, it's right here.
May I grab it?
Yeah, sure, go for it.
I just think we need
Yeah,
an
yep.
adjustment in one place on this. Oh, never mind, we don't. Because those two still run.
Yeah, yeah.
Perfect, my apologies.
Thank you.
Overthinking it.
No, you're good.
Yeah. Well, no, we're still there.
Oh, no, you're good. Thanks. Okay. Okay, so before we move forward with accepting the pleas, I just would like to hear from the parties. I mean, we have a lot of cases here, a pattern of allegations of pretty significant domestic violence and violations of a protection order. And so I'm just curious as to the thoughts underlying this plea, because I mean, there is a jail sentence and there is a probationary component. The jail sentence is certainly light considering the totality of the jail that Mr. Lopez could face. But Mr. Reed, I guess I'll start.
Sure. And Your Honor, so some of the things that this accomplishes is 3 domestic violence convictions, which means any further domestic violence convictions would be eligible to be habitualized and therefore a 5th degree felony. There are, I don't want to classify them as evidentiary issues, but I certainly anticipate and considered some issues securing a conviction at trial that were worthy of considering perhaps a lower jail sentence. Again, the primary thing from the people is that any further acts of domestic violence would be subjected to felony level prosecution, which I think was important.
Okay, thank you. Ms. Bernhardt, if you have anything you want to add at this point.
Yes, Your Honor. I mean, I would like to point out that in the matter of 2026 M260, the victim in this matter also did recently plead guilty to a harassment, strike, shove, kick with a domestic violence enhancer, and with which Mr. Lopez was the victim. I do think that just kind of goes to the sort of nuanced nature of this issue. Mr. Lopez is currently working on himself and working on any kind of potential anger issues. He is, prior to being incarcerated, he was involved in a talking circle at the Opinion Project. He was also going to a responsible fathers course at the Opinion Project. He has struggled on and off with homelessness and mental health, and he is working specifically with the Opinion Project in order to get mental health care and medications needed to kind of help him move forward successfully. I would like to note that the other 2 cases, the harassment case and the violation of the protection order case, are both misdemeanor charges. It does look like the violation of the protection order case, based on the facts and evidence presented to us, was largely mutual conduct between both Mr. Lopez and the protected party, Megan. And while we do understand that that's not an affirmative defense, I do feel that that should be a mitigating factor in any sentencing decisions that the court should make. And regarding the harassment charge, there were various witnesses around it that said different things. And I would also just like to emphasize again that it is a misdemeanor charge. All three of these charges are not felonies. And furthermore, Mr. Lopez has talked to me about different steps that he's taking to find employment. He did have a job remodeling a nail salon next to the Coco Pelli bike shop before being incarcerated. And he is hoping to get a job with a Mexican restaurant and working in the dish pit as a dishwasher. Mr. Lopez has looked at about 77 days total on all 6 of these matters, kind of on and off since October. And he does have 25 days credit in the matter of 2026 M260, in which there is a stipulated jail sentence. And then we would also, I don't know if that should be separate in the motion to violate or motion to modify the protection order. Mr. Lopez is looking to have non-harassing contact with Megan, and I do believe she is present in the courtroom today on arguing for the same with Mr. Lopez. They are married and working on the relationship and hopefully working towards being able to have a kind of positive and uplifting kind of partnership moving forward.
Well, guys, I certainly appreciate the statements made by the parties. I'm willing to tentatively accept these pleas. I want to see pre-sentence investigation reports in this case. I want to see recommendations from probation. I'm really curious whether probation will support these sentences. I'm willing to tentatively accept these things today, and then take a look at all the information that's before us and make a final decision at sentencing. And any issue with that from anybody?
None from the people, Your Honor.
Your Honor, would it be possible to move forward with sentencing in 2026 M260 today? Or
No,
it's a little-
nope. I'm gonna wait until I get a pre-sentence investigation report.
Okay, I appreciate that. Your
Yep.
Honor.
Okay. Well, Mr. Lopez, why don't we go ahead and run through these and make sure we're all on the same page? So, and then we'll address the protection orders after that. So in 25M 626, my understanding in that case is that you would be entering a guilty plea to the charge of harassment via strike, shove, kick as an act of domestic violence in violation of Colorado Revised Statute Section 18-9-111, subsection 1A. All remaining charges would be dismissed. Also, case number 26M277 would be dismissed pursuant to this plea. You'd be ordered to pay court costs and fees, cost of prosecution. You'd stipulate to proximate cause for purposes of restitution. You'd forever surrender and relinquish any and all weapons, drugs, currency, and other evidence seized by law enforcement. You'd be sentenced to 18 months of supervised probation. Terms and conditions of your probation would be open to the court. You'd be ordered to obtain a domestic violence evaluation and follow all treatment recommendations contained in that evaluation. Your probation in this case would run concurrent to your probation in case number 26M620. Also,
I'm sorry, Your Honor, 20M620 is the one that these will be consecutive to. Or, I'm sorry, no,
26
260.
case
260.
case will run consecutive to 26M260, and then this will run concurrently with 26M647.
That sounds right, Your Honor. My apologies for
As
interrupting.
part of this plea, case number 26M5027, 25M687, and 26M77 will be dismissed. Is that your understanding of the agreement?
Yes, Your Honor.
Okay. And then in case number 25M6 674. In that case, you would be entering a guilty plea to the charge of violation of a criminal protection order as an act of domestic violence in violation of Colorado Revised Statute, Section 18-6-803.5, subsection 1A. As part of this plea, all remaining charges would be dismissed. Also, 26M77 would be dismissed. You'd be ordered to pay court costs and fees, costs of prosecution. You would stipulate to proximate cause for purposes of restitution. You'd forever surrender and relinquish any and all weapons, drugs, currency, and other evidence seized by law enforcement. You'd be sentenced to 18 months of supervised probation. Terms and conditions of your probation would be open to the court. You'd be ordered to obtain a domestic violence evaluation, follow treatment recommendations of that evaluation. And then additionally, this case would run consecutive to 26M260. And then 26M626 and 26M647 would run consecutively to each other. Case number 26M5027, 25M687, and 26M77 would be dismissed. Is that your understanding of the agreement?
Yes, Your Honor.
And then in case number 25M626, no, I'm sorry, 26M260. In that case, you would be entering a guilty plea to the charge of third-degree assault, knowingly or recklessly causing injury as an act of domestic violence in violation of Colorado Revised Statute, Section 18-3-204, subsection 1A. That's count one. All remaining charges would be dismissed. You'd be ordered to pay court costs and fees, costs of prosecution. You'd stipulate to proximate cause for purposes of restitution. You'd forever surrender and relinquish any and all weapons, drugs, currency, and other evidence seized by law enforcement. You'd be ordered to obtain a domestic violence evaluation and follow treatment recommendations. You'd be sentenced to up to 90 days in jail. And additionally, case number 26M626 and 26M247 would run consecutively to this sentence. Case number 26M5027, 25M687, and 26M677 would be dismissed. Is that your understanding of the agreement? And then in all three of these cases, you're entering guilty pleas to
Correct.
charges that are classified as an act of domestic violence. Do you understand that because of that, you're going to have to schedule a domestic violence evaluation and complete 36 to 52 weeks of domestic violence treatment?
Yes, Your Honor.
Do you understand that if you're convicted of 3 or more cases that include an act of domestic violence, if you're ever charged with a 4th or more misdemeanor offense, you could be classified as a habitual domestic violence offender and charged with a Class 5 felony regardless of the class of misdemeanor offense?
Understood.
Do you understand that if you're not a citizen of the United States and you plead guilty or no contest to an offense that is an act of domestic violence, that plea could result in your deportation or exclusion from the United States or denial of naturalization in the United States?
Understandable.
Do you understand that by pleading guilty to an offense that is an act of domestic violence, that plea could make it illegal for you to possess, purchase, sell, trade, ship, or receive any firearm or ammunition?
Fine. Understandable.
And do you understand that by pleading guilty to an offense that is an act of domestic violence, that plea could make you ineligible for some federal government programs, including subsidized housing?
Yeah.
Okay. Mr. Lopez, have you had an opportunity to talk to your attorney, Ms. Bernhardt, about these, please?
Yes, I have.
Do you have any questions for her?
I do not.
Are you under the influence of any drugs or alcohol or any other substance or medication that might be affecting your thinking, your judgment today?
No, Your Honor.
Has anybody promised you anything in order to get you to enter these pleas today?
No, Your Honor.
Has anybody forced you in any way or threatened you in any way to get you to enter these pleas?
No, Your Honor.
Do you understand that by entering these pleas today, you're giving up several rights? You're giving up your right to a trial in these cases. At a trial, you'd have a right to call witnesses. You'd have a right to cross-examine witnesses that were called to testify against you. You'd have a right to testify on your own behalf if you wanted to, and you could also appeal any conviction to a higher court. Are you willing to give up all those rights today?
Yes, I am.
Okay, then in case number 25M626, to the charge of harassment via strike, shove, kick as an act of domestic violence in violation of Colorado Revised Statute, Section 18-9-111, subsection 1A, how do you plead?
Guilty.
In case number 25M674, to the charge of violation of a criminal protection order as an act of domestic violence in violation of Colorado Revised Statute, Section 18-6-803.5, subsection 1A, how do you plead?
Guilty.
And in case number 26M260 to the charge of third-degree assault, knowingly or recklessly causing injury in violation as an act of domestic violence in violation of Colorado Revised Statute, Section 18-3-204, subsection 1A. How do you plead?
Guilty.
So accept all your guilty pleas, find that they were entered knowingly, willingly, and intelligently. I will order that PSI evaluations be completed in each one of these cases. Mr. Lopez, if you're in custody, probation will come down to the jail and do those evaluations. If you're out of custody, you'll have to check in with the probation department as soon as possible and get those things done. Now we need to address the protection orders. And so let's start with case number 26M77. So we've got three cases, 26M77, 25M674, and 25M626. Do these involve different victims in each of these cases? These are all Miss Bayette.
Yeah, I think there's cases involving Miss Bayette and cases involving Ms. Knuckles, and I think there's requests. I think that both parties are going to make requests, both victims are going to make requests to modify protection orders.
Okay.
I think Mr. Lopez has a coinciding request to modify a protection order. And then while we're talking about it, I asked Ms. Bernhardt if she could just get Mr. Lopez's position on the case he's a victim in, modifying that protection order. She can feel free to email or call me or tell me in the hallway or whatever.
Okay, that case isn't on the docket.
That's not for you.
That's not for today.
It is, but not for you, and it doesn't involve Mr.
Okay.
Lopez as a defendant.
Okay.
And yes, Your Honor, I just wanted to point out, I do think that the motion we filed in case number 26M77 was a misfiling. I do not believe that Megan Bayette was the alleged victim or the protected party in that matter.
Okay, well, let's just address the protection orders this way. First, let's address the protection orders as they relate to Miss Bayette. And so I see Miss Bayette in the courtroom. Miss Bayette, would you like to make a statement?
Yes, sir.
Okay, be sure you're talking into the microphone there.
Sorry. I am currently Travis Lopez's wife as of October 21st. We had a meeting, I believe it was Monday, for a dissolution of marriage, but we decided not to go through with that because we want to work out our marriage and everything. As I've stated before, the reason the domestic violence they issued a protection order is because I have epileptic pseudo grand mal seizures. And he was trying to protect me and our unborn child, which I currently lost back in May of this year because of all the stress and everything, not being able to make the proper appointments or anything. I was currently in Grand Junction with the loss of my child with my father because Travis and I could not be together due to the protection order that was put in place. But we're just wanting to go from here and work on our marriage, work on everything that we need to do to hopefully make our marriage better, our relationship better.
Okay, thank you. Mr. Reed, what's the people's position on the modification?
People have agreed not to take any position on this, just noting the course of events today and the plea bargains entered. But I take no position on objecting or stipulating.
And Ms. Bernhardt, I think you already talked about the protection order. Anything else at this point?
Yes, Your Honor, I would just ask that the court follow the wishes of the protected party. I would like to note that any allegations regarding any physical harassment or altercation were back in November of 2025. And all further charges after that were for violations of the protection order, in which it, based on my reading of the discovery and the facts alleged, it did seem like it was largely mutual contact between both parties, and it was non-violent contact.
Okay. Just a second. So at this point in time, I'm not going to modify the protection orders as they relate to Ms. Bayette. Mr. Lopez entered guilty pleas to 3 cases today that involve acts of domestic violence. The allegations of domestic violence were significant. Mr. Lopez has yet to complete any treatment, and I, quite frankly, have significant safety concerns for the named victim in this case. And so I'm not going to modify the protection order as to Ms. Bayette and Mr. Lopez at this point in time. I understand Ms. Knuckles is in the courtroom. Ms. Knuckles, did you want to address the court? Okay, we'll get you a microphone.
So I am Brenda Knuckles. I would like the protection to have non-harassing contact with Mr. Lopez, if any possible. What I did to him in the past, I'm sorry for. I care for Mr. Lopez dearly, and I would like the best for Mr. Lopez. And hopefully, if I can get the protection order lifted, that he can do what he has to do. And I'm sorry for what I did to him. I love him, and I still care about him.
Okay, Ms. Bernhardt, what's Mr. Lopez's position as to the modification?
Your Honor, we take no position.
Fine.
Mr. Reed, any position from the people?
Your Honor, again, based on what's occurred, the allegations, people would object to a modification at this time. We think a no contact protection order remains appropriate.
Yeah, so I think that the no contact protection order does remain appropriate given the guilty pleas today, given the allegations in the case. And so at this point, I'm not going to modify the protection order as it relates to Ms. Knuckles and Mr. Lopez. Okay. So then what we need to do, we've got PSIs ordered in all 3 of these cases. We just need to get this set over for sentencing. And I'm looking at, let me just count here real quick. So,
I want contact with my wife.
August. So hang on. Mr. Lopez, please watch your language in the courtroom.
Judge Blue is the one that.
Mr.
even modified-
Lopez, I've made my order.
Hang on, I need to
Why
deal with
she's
this.
Involved in this with this case. Judge Blue is the one I
Try to
wonder
figure
with that.
out
So that this here, they're mixing 2 cases together here.
Hold on.
Judge Blue already modified it.
Oh, I'm not modifying it. So go
Yeah,
ahead and
well,
sign
that's
it.
on you. That's with over here. That's what I think Mr. Reed was pointing out there, that we already had a modification when I'm the one that got assaulted by her. And he
So Mr. Lopez,
modified it,
Mr.
but
Lopez,
my wife is the one I'm worried about.
I'm not
I want him.
I'm not trying to be rude here, but I've made my order. Okay. And so I'm looking at sentencing on August 20th at 9 a.m. Does that work for everybody?
Was that August 20th?
August 20th at 9.
It's already modified. That's what I don't understand. I guess.
And works for the people if I didn't say so, Your Honor.
So this isn't a modified protection order. This is just one that was emailed to the jail that was never signed. This was
So
one
this
that was
is-
previously in place.
This is the same one that was.
I know. I'm just trying to understand though
It was
why both of
ordered-
these cases are being heard together
It was-
when my wife
Travis,
is.
Travis.
I mean, it's a different judge.
Tra-
Judge Blue was the one that I was with that one. I mean, you have really no understanding what's going on with that, and I'm bringing it to light to you.
In Your Honor, if it helps provide some clarity, there's a case where Mr. Lopez
Yep.
is the alleged victim. These cases, he is the alleged perpetrator.
Yep.
They're not really, in my mind, it's appropriate for this court to handle these cases and that court to handle that
Absolutely.
case.
Absolutely.
So
Okay. There you go. So August 20th at 9 a.m. for sentencing. Does that work for you, Ms. Bernhardt?
yes, Your Honor.
Okay, August 20th at 9 a.m. We'll come back for sentencing in these cases. And we'll set the remaining cases for just a status conference at that date and time. I think that takes care of everything we need to take care of today. Anything else from anybody?
Nothing for the people, Your Honor.
Okay. We will be in recess, and I hope everybody has a good rest of your day.
Case number 25
Can you
CR
write that
173, we're covering for Division
Hold on
9.
one second.
Matter is before the court today for an appearance on an arrest warrant. You're entitled to a bond hearing. You may proceed with that if you choose to.
Yes, Your Honor. Thank you. The defense is asking that the court reinstate the $25,000 cash-only bond that was posted originally in this case. Ms. Epps is on WebEx. She had posted the bond on behalf of Mr. Mortensen. She does consent to this if the court agrees. I do have signed paperwork that I can upload as well for that consent of surety. Or like I said, she is on WebEx if the court needs to hear from her directly.
Let me hear first from the people regarding their position, and I'll give you an opportunity to respond.
Thank you.
Thank you, Ms. Marosich.
Heidi Bauer on behalf of the people, Your Honor. We would object to reinstating that bond. I recognize that the court is in a unique position, probably not familiar with this case.
Not
or
as
the-
much, but I've read it.
Okay. We've already gone to prelim and motions hearing, so obviously Judge Barrett was in a different position. I recognize that the defense is CPAC category 1 with no prior failures to appear. However, the facts of this case that he's shooting at strangers in multiple locations, making fake calls to 911 to try and draw attention away from himself, stealing a firearm, breaking into people's homes in the middle of the night and shooting at them. The one condition of his bond that was so important was to have no firearms. And then for him to be out driving around with 2 firearms, a 9mm and a shotgun, clearly this was not a mistake because he told the officer that he had the firearms and told them where they were. That's a clear violation of his protection order, his bond conditions. He's facing 2 crimes of violence, an extremely lengthy prison sentence. We are asking if the court doesn't want to send this back to Judge Barrett to deal with it, that the court increase the bond to $50,000 cash only based upon the extreme community safety risk with the defendant's behavior. Thank you.
Ms. Marosich, I'll give you a chance to respond.
Thank you, Your Honor. I appreciate that. So the new case that is referenced here was something that occurred on May 7th. So 7 weeks ago. The people did not file a motion to revoke Mr. Mortensen's bond in this felony case until June 23rd at 10 a.m. Judge Barrett granted that with hesitation about within an hour. And then Mr. Mortensen was arrested at his home that evening. So almost immediately, before I even had the chance to give him a call to tell him about said warrant, he was arrested on it and has spent the last 2 nights in custody before we were able to get in front of Your Honor for a bench warrant advisement. For this case, this new case, he did see a judge on May 8th and was granted a personal recognizance bond.
What's the new case?
So the case number, excuse me. 26 CR 173.
It's an M.
Is that, oh, I'm sorry, M.
It's 1274, 26M 1274.
Thank you. I'm trying to read text layered on top of each other here. And that's the basis for the people's request to revoke the bond, is that new case.
That's 26M1.
1274.
Oh, what I wrote down at all. Sorry about that.
Yes. So in that case, Mr. Mortensen is charged with a 1-count Class 1 misdemeanor violation of protection order, a Class B traffic infraction for expired driver's license, and a Class B traffic infraction for a tail lamp violation.
And it was in that case that he was allegedly driving around the community shooting at people?
No, that is
happened.
not an allegation anywhere, that he was driving around shooting at people. The underlying facts of the case in front of Your Honor do involve a firearm, and alleged shots against individuals. That's the case that he has the $25,000 cash only bond on.
And then in May, he was driving around with another firearm.
2. Yes.
And it's based on this new case, 26M1274, that the people elected 7 weeks after the fact to seek to revoke the bond here in this case. Mr. Mortensen is not a danger to the community that would warrant increasing the $25,000 cash only bond based on this new allegation that he received a personal recognizance bond on. As part of that case, in the past 7 weeks, Mr. Mortensen has done everything he has been ordered to do by that judge. He was ordered to appear on May 13th. He did so. He was ordered to file a firearm affidavit. He did so. He was ordered to submit a new public defender application, since there's a new case. He did so. He was ordered to appear again on May 29th. He did so. He did all of these things over the past 7 weeks. Also in that time, Mr. Mortensen has maintained his compliance with pretrial services. So that was a condition of the bond in this case in front of the court, specifically a scram monitor, as alcohol was intricately tied to the alleged actions on the date of offense here. I did contact pretrial services to see if they had any kind of update for me yesterday morning. I had not received word back from them. I did follow up again this morning, but I know there's just a few people that monitor all of the different individuals. But generally speaking, no news from pretrial services is good news. That the fact that there have not been any pretrial reports since he's been out on this $25,000 cash only bond indicate that he has been in good compliance with that scram monitor and with pretrial services supervision. Mr. Mortensen has also appeared for every single court appearance in this case, 25 CR 173. So he's done everything that he's been ordered to do in the 26M case, and he's made all the appearances and done all the pretrial services as part of the bond in this case. Mr. Mortensen does not have any convictions on his criminal record of any level, whether felony or petty offense. He has these 2 open cases, one with the PR bond that is being used to try to revoke his bond that he has been otherwise in great compliance with. Mr. Mortensen is also, as Ms. Bauer noted, a Category 1 on the CPAT instrument. That is still the case even in the second case that was filed. Mr. Mortensen grew up in this community. He moved away for a couple of years when he was a child, lived in Florida for a few years, and then moved back. He's only 24 years old, has spent most of his life in the community. He is married. He lives with his wife, Bree, and her sister, and that's where he was arrested at his home. He's also employed. He's been working the last several months since he's been out on this $25,000 cash only bond as a cook at the Little League here in Grand Junction. He's also connected with mental health services here in town. So he was incarcerated for quite some time before this bond was adjusted and he posted it. But in the months that he has been out, he connected with Colorado Health Solutions and has been going twice a month to counseling services with them. My understanding is that may increase as well as Mr. Mortensen has various stressors in his life. So it's the defense's request with the consent of Ms. Epps, who is on that WebEx and signed that consent that I can file with the court to reinstate that cash only bond here.
I don't show that his bond was adjusted. I show that he had a $25,000 cash only bond set in February of 2025 that he
Oh, I apologize.
eventually posted in January of 2026 through Ms. Epps's organization.
Yes, I apologize, Your Honor. I meant that it had been posted at that point. But he had been incarcerated for almost that year leading up to that.
Looks like he was picked up on that. Yeah, he was taken into custody in February.
And Your Honor, if I could just briefly respond.
You certainly can, Ms.
The reason for the filing 7 weeks after he received those charges is pretrial services never notified us. They didn't file a report. Our paralegal just happened to find out about that case. I immediately contacted pretrial services. I don't know if they fully understood that the no weapons was a condition of the protection order, which was a condition of the bond. When I explained the circumstances, they did file that report immediately, which went to the court, who then issued the no bond warrant. And I would just disagree with most of what Ms. Marisich just said. The defendant did not comply with the conditions of bond in the underlying felony. He was to not have weapons in his possession, and he had weapons in his possession.
So that the people were delayed in securing the safety of this community for whatever reason, and it sounds like there's some justification, does not erase for this case, for this court, the fact that the community was placed at risk. Sir, after a long stint in jail, you had a bond condition because of the weapons involved in the underlying case or allegedly involved to not possess weapons. Your failure to take that seriously, your presence in the presence of weapons in a vehicle where you could have easily gotten to those weapons, put this community at risk. The one bond condition that secured the community from the risk that you presented as a result of an alleged weapons-related case was that you not be in possession of weapons. That was an easy rule to follow. It wasn't a hard thing to know about. And you, for whatever reason, and maybe you have your own reasons as well, didn't take that as seriously as you should have. That presents an inordinate risk to this community. Bond is modified to a $50,000 bond, cash only. If you want to address that again in whatever manner that might be appropriate before Judge Barrett, you may do so, but I find an increase in bond to be not only warranted, but necessary in this case in the interest of community safety. Bond conditions are real. If they don't mean anything, we can't keep communities safe. Bond conditions have meaning before this court. Thank you. Would the people like to proffer a plea?
Yes, Judge. Are you ready?
I'm
for me
ready,
to go
yes.
ahead. I just want to make sure.
Thank you.
All right. Your Honor, at this time, Mr. Pauls will be pleading to count 4 and count 5. Respectively, those are M1 third-degree assault on a pregnant person in violation of CRS 18-3204 and M1 harassment, strike, shove, kick in violation of CRS 18-9-111. Those are acts of domestic violence as indicated by the check mark in the box directly under that language. And then under sentencing terms and conditions, how this is going to play out. Count 4 is a stipulated term of 6 months in the Mesa County Detention Center. Count 5 is a stipulated 18-month supervised probation with a domestic violence and substance abuse evaluation and comply with any treatment recommendations from that. Any other terms and conditions are open to the court. And then his criminal history is outlined under on the second page would the court like me to indicate why we are doing a misdemeanor plea versus a felony plea? I know you usually do like some of that.
If you would like to make that record, you can. I am certainly familiar with some of the arguments and certainly the proceeding that occurred earlier in the week.
Okay, I will make it brief. At conversations with Ms. Swift and myself, we have been talking about the felony counts in this case. The strangulation or the attempted strangulation was stronger than the F for aggravated or assault with a deadly weapon. I think within our conversations and our review, there was some questions as to whether that might be bound over at the preliminary hearing. And if you're looking at the criminal history section, Mr. Pauls only has one prior domestic violence conviction. That is from 2011.
Mhm.
So I think this is an appropriate plea, and I can make further sentencing arguments when we get to that point.
Certainly. Thank you very much, Ms. Wright. Ms. Swift, is there anything further you would like to present at this time?
Judge, I do think we need a record on VRA. Ms. Liverman is present.
I will note that Ms. Liverman is present. I'm glad we were able to get her here today. And that does make record for VRA that she received notice of these proceedings. Has she received notice of this plea and an opportunity to weigh in on that?
Yes, Judge. I
Okay.
complied with VRA on at the request of the people and have explained this disposition to her, and she is in agreement with it.
Okay, thanks. And I can also inquire of her if she'd like to be heard. So, Mr. Pauls, I have some questions for you. Are you ready to answer some questions today? My first question is a question that I don't want you to think is suggestive in any way. I ask it of everyone that I take a plea from. Are you of clear mind today so that you could make an important decision regarding yourself?
Yes, ma'am.
Thank you. Did you have an opportunity to review all of this plea paperwork with your attorneys?
Yes, I do.
Do you feel like you understand it?
Yes, ma'am, I do.
Do you understand what this plea requires of you?
Yes, ma'am.
Do you understand what this plea prohibits you from doing?
Yes, ma'am.
Do you understand that by entering a plea of guilty to count 4 in this case, you will be admitting that on or about May 12th of 2026, you did unlawfully and knowingly and recklessly cause injury to Rachel Liverman?
Yes, ma'am, I do.
Do you also understand that you will be further admitting that she was pregnant at the time and that you knew or should have known that she was pregnant at the time?
Yes, ma'am, I do.
Do you also understand that by entering a plea of guilty to count 5, you will be admitting that on or about May 12th of 2026, you did intend to harass, annoy, or alarm Miss Liverman?
Yes, ma'am.
And are you further admitting that you did either unlawfully strike, shove, kick, or touch her or subject her to physical contact? All right. Do you further understand that by pleading guilty to each one of these class 1 misdemeanors, you would be potentially facing up to a 364 jail sentence and up to a $1,000 fine on each of the counts?
Yes, ma'am.
And do you understand that on the count 1, as a result of the pregnant victim designation, there would be a mandatory minimum sentence the court has to impose in that case? And you understand that's a 6-month sentence. Has anyone made any promises to you to get you to enter into these pleas that are not contained in this plea paperwork?
No, ma'am.
Have you ever served in the United States Armed Forces?
No.
Do you understand that you have a right to a jury trial at which the people would have to prove beyond a reasonable doubt that you committed each element of each offense?
Yes, ma'am, I do.
Do you understand that throughout the course of that trial, you would have the right to be represented by an attorney and to cross-examine all of the people's witnesses?
Yes, ma'am, I do.
You understand that you're presumed innocent and that you have the right to remain silent?
Yes, ma'am, I do.
Are you prepared to waive all of those rights in order to go forward with this plea today?
Yes, I am, ma'am.
Are you doing so voluntarily?
Yes, I am.
Do you understand that if you had any appellate rights leading up to today's date, by entering the plea, you'll be waiving your right to pursue those appeals?
Yes, ma'am, I do.
Do you also understand that if you have any concerns regarding the legality of the sentence I impose, you will still have 49 days to seek an appeal regarding that sentence?
Yes, ma'am, I do.
Do you further understand that by entering a plea, you're waiving your right to seek any Rule 35B reconsideration of the sentence? Then with all of those understandings, Mr. Pauls, are you prepared to proceed today to enter pleas of guilty to both of these charges?
Yes, ma'am.
How then do you plead to count 4, class 1 misdemeanor, third-degree assault on a pregnant person in violation of Colorado Revised Statute, Section 18-3-204?
I'm more than guilty, Your Honor.
Thank you, sir, for your honesty. And how do you plead to count 5, class 1 misdemeanor harassment in violation of Colorado Revised Statute, Section 18-9-111, subsection 1?
I'm guilty.
Ms. Swift, will you stipulate that there is a factual basis to support the entry of both of these pleas?
Yes, Judge.
Based on that record, I find that you've knowingly, voluntarily, and intelligently pled guilty to each of these charges, and we will proceed directly to sentencing today. People may proceed with their sentencing arguments.
And before I say anything, I would ask if Ms. Liverman would like to make any comments that she be heard.
Ms. Liverman, if you would like to be heard for sentencing, I would very much be happy to hear from you. We can get you a microphone. You're welcome to sit right there. We can bring you to the podium, whatever.
I think that the deputies would prefer if she's.
Okay, then we'll put you right there and we'll bring you a microphone so that you can be heard.
Well, I wrote all this down actually, but I was mostly apologizing to Zane for bringing him back to the Western Slope and feeling like I failed him as a wife for getting him high again and just, I was hoping that he could find forgiveness for me. So actually the outcome of this is really the best for me. I'm really excited because that means that he could be there when our baby's born. So I'm actually really happy with all of this. Even though I'm crying, it's just emotions from the baby and just, I'm really happy actually. So that's all.
Thank you very much, Ms. Liverman. Ms. Wright.
I wanted to start off with, I hope that Ms. Liverman feels heard at this point and listened to. I know that there had been comments prior at different hearings, and so we did listen to those comments that were made. Looking at this case in particular and Mr. Paul's history, I know he does have a history of felony convictions starting back in 2012. But because this is a misdemeanor plea, I'm not really going to outline those for the court. They are outlined in the plea agreement. And as I've noted already, he has that one domestic violence conviction from 2011. What I would note for the court is that a lot of this is on surveillance video. I think both the defense and myself had several clips that were prepared to be presented at the preliminary hearing. I do truly hope that this outcome makes Mr. Pauls recognize just how, just what he has in Miss Liverman, the fact that she is standing beside him, the fact that she has supported him, the fact that she has tried to take responsibility for some of this, even though as a domestic violence prosecutor, I don't think she has any responsibility, but I appreciate all that she is saying. I think that the best outcome here is getting him treatment for the alcohol and substance abuse issues, and and the domestic violence treatment. I want to say, I can't remember off the top of my head if there was treatment involved in that 2011 case. There might have been, but I can tell you treatment in 2011 is very different than treatment now. And so I really do hope that that treatment is beneficial to Mr. Pauls and to Mr. Liverman and, or Miss Liverman, I'm sorry. And I hope that they can get things worked out for the sake of the child.
Thank you, Ms. Wright. Ms. Swift.
Thank you, Judge. We believe that this is a fair disposition. I'd done a lot of work to be ready for this preliminary hearing to show the court that this is exactly what my client did and not the things that he is charged with, especially not the assault with a deadly weapon. That is not caught on video. There are 0 witnesses that say that he possessed a knife. There are 0 witnesses that say that the injury was caused by a knife. A tiny knife was found in a area that lots of people can access. That knife is, there's no other evidence tying that knife to my client. That Ms. Liverman has given the exact same explanation of how she obtained the injury to her arm, which was that she ran into a cabinet. There is missing close-up video from when this injury occurred that just, for whatever reason, has not been turned over, which is very fishy, given that if it was motion activated, it should exist for when she was running into this area and hit the cabinet. But there is video from a neighbor that shows a further distance. It's somewhat obstructed, but it shows the two of them running. It shows the cabinet shake as she falls down.
Okay.
So it's really quite likely that she's been telling the truth the whole time, and that this is not a situation of a recanting domestic violence victim. This is someone who's given the same statement every single time. Now, what is caught on video is domestic violence conduct, absolutely, and that injury was caused by Mr. Paul's reckless conduct of getting into a physical altercation with her, chasing her, which caused them both. They both fell. He skinned his knee, and there was documentation of that, and she got this injury to her arm. So he is responsible for causing that injury, as well as for the throwing her to the ground earlier in the fight. So he is, and that's exactly the conduct that he's pleading guilty to right now.
Okay.
And I think that this is a very appropriate disposition. He has been interested in pursuing treatment. That's something that we've been working on. And I hope that he will be able to work out a good transition plan after he finishes his jail sentence to get some treatment. And the way that this was the disposition proposed by Mr. Pauls and myself. And this,
what are your thoughts regarding how I make the domestic violence treatment piece of this real for Mr. Pauls? Because it's not a probation sentence as I read it. It's just a straight DV, and I still need to impose the treatment component. And
so we stipulated, which I believe is in misdemeanor cases, the court can impose a jail sentence on one count and a probation sentence on another count.
Are you stepping to probation on one?
And
did I miss
yes,
that?
That is in the plea agreement. And again, that was our proposal.
Can you direct me to that?
To count 5, the plea on harassment.
Found it.
18 months probation.
All right.
Substance abuse
That works.
evaluation and
Good.
comply. Domestic violence evaluation and
Yep.
comply. And we proposed that because Mr. Pauls really does want to get help. He's had that experience where he did inpatient treatment, stepped down to sober living while he was in Pueblo, and that was going very well.
Okay.
As the court has heard, after he came here, he relapsed. But the idea here is that he will have time to finish his jail sentence and hopefully get his feet under him with a period of treatment and sobriety by the time the baby comes.
What's his credit time served?
45 days credit time served. He is participating in JBBS in custody. I think that this is all the best way to hopefully get these folks on track to be able to be parents to the child that they are expecting. It was added as a stipulation of the plea agreement that the no contact order would be modified to allow full non-harassing.
I did see that.
So yeah, I think, is there anything else I need to say?
Thank you.
Yeah.
Thank you. Mr. Pauls, you have the opportunity to address the court at this time if you want to. I'll certainly hear from you.
She's right. She doesn't have no responsibility. I should have been a better person. Man, I shouldn't have ever assaulted my wife. And I was the one that wanted to take accountability. That's why I had them read me my Miranda rights, and I told them I was wrong. She wanted me to shut my mouth, but I knew that I was guilty of what I did. So I wanted to take accountability for what I did.
Thank you,
Because I
Mr.
know that I
Pauls.
deserve that.
It is not very often that I have two participants in a domestic violence squabble come before me fighting about who's the most responsible in the event. But what I can say is that in every single appearance where Ms. Livermore has been here, she has insisted that she was responsible, and she has always consistently taken responsibility for whatever her role in this was. And I certainly want to honor Ms. Livermore for taking responsibility for her honest role in this, not more than that, but certainly in these types of circumstances, there's often two sides to a story. Rarely is there ever a marital dispute where there isn't something like emotions coming from both sides. Those are the things that we need you all to learn how to work out without violence. Certainly, as Ms. Livermore has reflected, and as Mr. Pauls is recognizing, the absence of drugs and alcohol will greatly contribute to your ability to sort these kinds of things out without violence between one another. And so I really want to encourage you both to work toward the sobriety that you both say you're so interested in achieving. I do genuinely think that that will make a significant difference in your ability to go forward together as a couple and as parents together as you look forward to these next roles in your life. Mr. Pauls, you too have also been incredibly consistent in taking responsibility for your role in this. You've always admitted to what you understood that you did in this case. You've held very firm against allegations that you didn't think fit, but you have never just outright denied your involvement, and the court has certainly recognized that. I do believe, based on all of the facts that I know at this time, this is an appropriate resolution. I consider a number of statutory considerations when determining an appropriate sentence. Those are whether or not the punishment is commensurate with the offense. I find that it is. Whether this is a fair and consistent treatment, considering all of the factors, again, I find that it is. Whether there's sufficient deterrence and rehabilitation built in. I didn't read the fine print on this, and I was concerned about that, but now I understand it, and I do find that we have built in sufficient opportunities for rehabilitation and deterrence as well. I consider your individual circumstances and the degree to which you take accountability. And as I've said, Mr. Pauls, you have never denied that you struck your wife. You have never denied that you knew she was pregnant. You have admitted that openly without reservation in proceedings before this court. A lot of people wouldn't have done that, and I think it's important that we recognize that. And we also consider, very importantly, what can be done to restore victims and put them back into the best place. Mr. Pauls, you're very recalcitrant. You recognize that you shouldn't have treated your wife this way. Going forward, I hope you'll stick to that resolve, because she surely doesn't deserve to be treated that way. No woman does. And you've said many times before this court that you are not biased against women. I want you to know that I am not biased against you. I expect you to come here and take accountability for the things that you rightfully should take accountability for. But you zealously raising a defense for the things that you do not believe that you are responsible for is part of what makes this system work. You have a right to a defense when you raise a defense. There's some procedural rules we have to follow when we do that. And when Ms. Livermore has come before the court, I've had to remind her a little bit of those procedural rules as well. That is how we keep the order about what we do, so that this can be a fair place where we can sort out these issues in the most fair way. If we all come in yelling and screaming and being disruptive with one another, we can't really get to the heart of the matter. And that's the purpose of the procedural rules that I have held both of you to at various times. It was never because I didn't want to hear from you, never because your words and your voice were not important. Please know that. Based on that record, I find it is appropriate to impose sentence as follows. On count 1, I will sentence you to serve 6 months in the Mesa County Detention Center. That is the mandatory minimum sentence for that count. I will give you credit for time served of 45 days. On count 5, I will sentence you to serve 18 months on supervised probation. I will require, as a condition of that probation, that you obtain a substance abuse evaluation and comply fully with recommendations for treatment. I will also require that you obtain a domestic violence evaluation and comply fully with recommendations for treatment. In the course of that probation, you must maintain sobriety. You must demonstrate that you are maintaining your sobriety. Those are the most important components of the sentence. And the most important thing that you can do to move forward as a new parent. I will require that you pay court cost fees and surcharges. I am not otherwise going to impose fines. I would rather see that money go toward the treatment that I think will be so beneficial for you. I will modify the protection order to allow you both to have non-harassing contact with one another. So going forward, you may continue to reside in the same home. You may continue to have to be in one another's presence. There is still a protection order. I don't want you to miss that point.
Yeah.
And so if there's an argument that breaks out, any behavior that could arguably be harassing, calling names, poking fingers, striking one another, those types of behaviors, you cannot do those. You have to instead walk away and keep your wits about you. But you may have contact so long as it is not harassing. I wish you both the best as you move forward in these next chapters in your life. You have made statements, Mr. Pauls, that because you're a convicted felon, that doesn't drive your behaviors going forward or how you should be perceived going forward. You've paid your debt to society for those prior crimes. You're paying your debt to society for this one as well. But once that is closed, it is closed and you may move forward with your life. I would like to honor that and acknowledge that. Thank you both.
Right.
The remaining charges are dismissed. And you are released on this. Well, as soon as you're done with your 6-month sentence, you're free to be released to probation. As soon as you've completed that probation, that 6-month sentence, please do check in immediately with, probation. Thank you. Anything further from the people?
Just real quick, I think I forgot to say this when I read the plea agreement, and I can't remember if I heard it any other time. These two counts, since they're different dispositions, they will run concurrently. That's the agreement.
We will note that they run concurrent as they're arising out of the same facts and circumstances, same case. It's very appropriate for them to do so. So probation technically on that starts today. So even though you're not really checked in, but it does technically start today if you're counting your 18 months.
Okay, thank you.
So it's possible that means that probation will get notice and will come see you in the jail. But if they don't, it's your job to get over there as soon as you get released.
Okay.
Yes.
That's fine.
Very important that you do that. Don't forget that piece.
Wow.
That'll cause us to be back on our revocation. We'll try to sort it out as fast as we can, but it's better if we don't have to do it.
I just do want to clarify one thing for the record. I believe that the court imposed a sentence on count 1 of the 6 months jail, and the court, I'm sure, meant to say count 4.
I did. If I said count 1, I meant to say count 4. It is indeed count 4. That's what we've led to.
Everything's clear.
We'll make sure that's clear. Thank you.
Thank you.
Best of luck to you all. Thank you. Are the people seeking cost of prosecution or restitution?
Was there any? I don't remember. I don't think so.
Do we need to bring Mr. Pauls back just in case? I don't want him to be surprised by that.
The plea agreement said no, right?
I think I looked, and I think I looked before I did the plea agreement to make sure, and I didn't see anything, but I just want to double check before I say that.
Sorry, man. We're just making sure there's no restitution or anything, cost of prosecution.
I don't see anything referenced in the plea agreement, so no restitution, no cost of prosecution. Mr. Pauls, I had told you when you entered your plea, you have 49 days to seek an appeal. If you think anything is unlawful about the sentence, you do indeed still have that time frame. All right. Thank you.
Okay, we'll call 26T135, 26T192. This is Eric Gallegos.
Judge, we might
Is Eric
want to
not here?
pass. No, he was here a minute ago. He's completing a public defender application. I think he went in the hall.
How are you doing on your application? If you're not done, that's okay. It's just, you're not done yet?
Well, I filled out right, but some stuff's on that.
Regarding income? Your income?
Is it on income or what do we? Yeah. Okay, I'll tell you what, let's call Jonas Carpio. Come on up, Jonas. This is 26T189. Bring that with you, though. Bring that clipboard, and let's have Stacy look at it.
I'll see if I can pin down Mr. Gallegos.
Yeah.
Stacy, are we close?
Yes,
Do we have enough to get him to the public defender?
yes.
Stacy, can we get him back here on July 2nd? Okay, you're going to come back here on July 2nd at 8:30. If I appoint a public defender to represent you, they'll give you a different court date, but right now, your court date's July 2nd at 8:30.
Okay.
Do you have any questions?
No.
Okay. I want you to reach out to the public defender soon, because if they need anything else like income verification, they're going to need that from you, okay? All right. Thank you, Mr. Carpio.
I can take that one too.
Sorry.
Okay, let's go 26T123, Arabella Paniagua. Good morning. Doesn't your mom usually come with you?
Yeah, she couldn't today.
She couldn't today, so you're comfortable doing this? Are you, how old are you?
17.
Okay. Mr. Chow, what are we doing?
Yes, Your Honor. In this morning, I made an offer to Ms. Paniagua, and Ms. Paniagua indicated that she would like to accept. The detail of the offer is that Ms. Paniagua agreed to plead guilty to count 1, driving without driver's license, and count 2, amended speeding 5 to 9. The count 3 and 4 are going to be dismissed in exchange. Ms. Paniagua indicated that she would like to accept that offer and would request Your Honor to accept her plea.
Okay, we're getting rid of 3 and 4, and she's going to plead to the original count 1, and you're changing speeding to
5 to 9, Your Honor.
5 to 9. And this is what you want to do today?
Yeah.
Do you want to wait for your mom to be here, or are you comfortable doing this by yourself?
I could do it.
You sure?
Yeah.
Okay. Okay, I want to make sure that you understand what your trial rights are that you give up when you plead guilty, okay? You do have the right to plead not guilty and have a trial to a jury or to the courts. You have the right to be represented by an attorney, and if you couldn't afford an attorney, you could ask me and I could appoint one for you at no cost to you. You're right now presumed innocence of everything that you've been charged with, and that presumption stays with you until the people can prove beyond a reasonable doubt that you've committed the offense. If you went to trial, you could confront any witness that's called to testify against you, and you could cross-examine those witnesses. You would have the right at trial to present your own evidence, and if you needed help, you could ask me, and I would issue subpoenas and compel other people to come testify on your behalf. At trial, you'd have the right to remain silent, or you could testify in your own defense. If you decided to remain silent, nobody could use your silence against you. If you went to trial and you didn't like the way that trial ended, you could appeal the findings of the trial to a higher court. So those are your trial rights, and you give those up when you plead guilty. Do you understand those rights?
Yeah.
Okay. So you have 2 different charges that it looks like you're going to be, that you possibly pleading guilty to. And Mr. Chow here has done a few things. He's going to dismiss 2, 3, and 4. And number 1 is going to remain the same, and that's driving without a driver's license. And what he would have to do is prove that, let me just make sure I'm getting the right one here. So he would have to prove that you were driving a motorized vehicle in Los Animas County, Colorado, on or about the date alleged in the complaint, and that you drove the motorized vehicle on a highway in our state of Colorado, in our county, but you didn't have a current valid driver's or minor's driver's license or an instructional permit issued by the Department of Revenue. You just didn't have a license, okay? This is a Class A traffic infraction. And I'm gonna tell you the penalties in that 1 second, because the other thing that you're gonna be pleading to is the same thing. The other, Mr. Chow and you have agreed to is, instead of pleading to the speeding of 10 to 19, he's lowered that to 5 to 9. So the elements of that offense is that you were driving a motorized vehicle in Los Animas County, Colorado, on or about the date alleged in the complaint, and that you were driving at a speed of 5 to 9 miles an hour over the maximum posted speed limit. Okay, that too is also a Class A traffic misdemeanor. Now, a Class A traffic misdemeanor, you're looking at a maximum fine of $100. Those are the elements that he would have to prove at trial for somebody to find you guilty. And those are the possible penalties. Now, there is one other penalty that I want to talk to you about. This is going to result in a 1-point violation that will affect your privilege to drive. And we'll talk about that in 1 second, okay? So those are the possible penalties, the 1 point and up to a $100 fine for each one of those charges. The 1 point only for the speeding. Do you understand the elements and the possible penalties? Okay. What happened the day that you were driving and you got pulled over?
I was driving on Santa Fe Trail and I was driving up this way, and the speed limit's like 30 over there, and like if you go a little bit more it's like 35 or something.
Okay.
And I didn't realize I was going fast, but I was going like 45, I think. And
Okay.
then a cop saw me, and then I was more up Santa Fe Trail, so I didn't think he was pulling me over, but he did.
But he did, okay. Well, just based on the statement, I know that there's a factual basis for me to accept your plea, so I appreciate you saying that. Now, is this what you want to do?
Yeah.
Is anyone coercing you to do this?
No.
Okay. Right now, are you under the influence of any stress or prescription medication, drugs, alcohol, anything that would make you not understand what we're doing today?
No.
Okay. Now, I'm sitting here, this is a court of law. The Department of Revenue runs something, the Department of Motorized Vehicles. They deal with your privilege to drive, okay? You're gonna have 1 point assessed against your privilege to drive, so I just want you to know, and I make sure that you understand that there's a difference. Like, this is law, that's privilege. It's confusing, but I wanna make sure that you understand that if you do enough things, and I don't know how these charges are gonna affect your privilege to drive, but I want you to know that there's a difference and there could be other consequences based on this plea today. Do you understand that?
Yes.
Okay. Now, how do you plead to driving without a license and speeding 5 to 9 miles an hour over the posted speed limit? Do you plead guilty or not guilty?
Guilty.
Okay, thank you very much. I will find that Ms. Paniagua has entered her guilty plea to the charges voluntarily with the full understanding of her rights, the nature of the charges, and the possible penalties. So I will accept your plea, and we're going to enter a judgment on that. Mr. Chow, what would you like to say about possible fines, cost, fees? And
Yes, Your Honor, the people would request Your Honor to impose a minimum amount of fine, suspend them if possible. Ms. Paniagua is still under age of 18. The people make this offer in consideration of that.
Okay,
probably
very
all
good.
the record.
Ms. Paniagua, is there anything you want me to know before the sentence is going to be you're going to have to pay some money. Is there anything you want me to know about this before I do that? Okay, that's fine. You're good to, you don't have to tell me anything. But we're going to do a $50 fine, suspended in position.
As a minor, there's only certain fines that we can.
Can you get rid of and stuff? Yeah. Or enter, yeah. Yeah.
So for total bar costs and fines are $30.50.
Perfect. $30.40, 50 cents. So if you can take care of that today, please do. Okay. If you can't, I want you to go through and talk to the clerk's office there. They can help you get put up on some sort of payment plan. Okay.
Okay.
Thank you very much.
Thank you.
Take care.
You too.
Okay. Good morning, Chris.
Good morning.
How are you today?
I'm doing well. How are you?
Good. I'm good, thank you. Did you get the paperwork I just sent you a few minutes ago?
Me?
Yeah.
No.
Okay. I forwarded to you an email from Mr. Chow, the DA, on this case.
Okay.
And it's the paperwork. But listen, what I'd like to do is, rather than doing anything today, because I don't want you to feel rushed, why don't we just continue this for a day in the near future, whatever the court can accommodate. I'd like, say, the next week, if that's acceptable. I'll do it off my docket day so I can come over here and we can begin, the process of resolving your case.
Sure. Yeah, I'd like to take a look at that. I usually don't check my personal email until the afternoon or after I get off work. And so it may be sitting there and I'll check it after we conclude this morning.
I don't check my professional email often enough, so at least it's your personal email. But no, so that's great. That's great. That's what we will do then. And thank you. And the judge will be out in a few minutes, so please be on standby.
Okay. Thank you.
Yeah, that'd be great.
Are you available Wednesday, July 1st in the afternoon?
Let me see. I bet you I am. Russ, are you available Wednesday, July 1st in the afternoon?
Let me check.
I'm
Yes.
totally available. Good.
Yes.
Mr. Chow, are you here? Yeah. Good. That'd be great, Stacy, please.
What time?
Just a second, Chris.
Okay.
I can, can do the 1:15.
That'd be great. 1:15. Is that okay?
Yeah.
Okay. Thank you all. Okay, but don't go. We need to have the court call the case and reset it. Thank you, Mr. Chow. Yes, ma'am. Yes.
And for the others, for Mr. Amijo and Mr.
Yeah, they are, right, they are returns with counsel. And so if we could please just reset. Is that okay?
Yeah, sure.
Good, thank you. And I think I may have discovery on all of them.
Yeah, I just reviewed the discovery and I haven't speak with the victim yet, so I'll need some time as well.
Okay, good. So you won't object?
Yeah.
Good. How's everything going, sir?
Smooth.
Good. Nice.
I had quite a big docket yesterday, but I
did you?
It went well.
All right.
Good afternoon, everybody. You may be seated. Or good morning, maybe.
Right, whatever. All
morning, Your Honor.
Doing good. How are you, Mr. Downs?
Good, thank you, Your Honor. How are you today?
I'm doing great, thanks.
Good. And we have Mr. Ryan on virtually, Your Honor.
Very good. Mr. Ryan's on. You want to call that one first so we can get him going if he wants to?
Please, Your Honor, that'd be great.
On here. Okay, let's call 26T43. This is Christopher Ryan. We've got Mr. Downs for the defense, Mr. Chow for the people. What are we doing today, Mr. Downs?
Your Honor, if we could please, we have a disposition that we would like to, we're not ready to enter into it quite yet.
Okay.
But we will be, and I've received the paperwork from Mr. Chow. I've sent that to Mr. Ryan. Mr. Ryan and I just need a little bit more time to go over that, please. So, Judge, I have taken the liberty of getting a day for next week.
Okay.
If that's okay with the court.
I'm fine with that. Mr. Chow, are you good with that?
Yes, Your Honor.
And so, Your Honor, our proposed date would be Wednesday, July 1st at 1:15 p.m. Ms. Garcia tells me that date is available, and if that's okay with you.
Sounds good to me. Let's get a plea done next, what is that, Wednesday?
Yes, sir.
Okay, sounds real good.
Good.
Mr. Ryan, we'll see you back in my courtroom in, 6 days?
Yes, sir. Thank you.
Okay, keep in touch with Mr. Downs. He may need some signatures on some paperwork, but I'm sure that'll be easy enough to take care of.
Okay, yes, sir.
All right, take care. Thanks.
Thank you, Lord. Thank you, Mr. Ryan.
Okay, Mr. Downs, call him as you see fit.
Okay, Your Honor, thank you. How about the case of Joseph Morgan, if you would, please?
Okay, it looks like we got a few of these. No, we're following a criminal case, civil case. Never mind. So this is 26M59, Joseph William Morgan.
Your Honor, thank you. And on behalf of Mr. Morgan, I am Les Downs' attorney. Judge, I believe this is set for a return with counsel. And so if it's okay with the court, I told Mr. Morgan I didn't think he would need to be here this afternoon. I will make sure he has his next date. And I know you're going to ask me when my next date.
Yeah, if you have one, great. If not, let's get Stacy a date so we can keep you on our calendar. Is that enough time?
I think it is, Your Honor. I mean, we can at least begin plea negotiations. And sure, so the 16th. Well, the 16th.
This case is not that old. I've seen Mr. Morgan a few times, so just pick a date that's comfortable for you.
Why don't we go into August if we could, please, Stacy? Just because that's really only about 2 weeks out.
What do we have, August 6th today? What did we do this morning, Stacy?
August 12th. Not quite 6.
You know, I'm sorry, I have a permanent orders hearing case in Warford County that's scheduled for a whole day.
August 18th.
That's fine. That's fine. Yes, ma'am. Anytime that day.
Mr. Chow, is that available for you?
Yes, Your Honor.
You guys meet?
Yes, ma'am.
It looks like maybe 10:45.
2 o'clock or 10:45, I'm sorry.
Yeah.
Which one do you want?
How about 2 o'clock?
Perfect.
Because I already started to write that in my calendar.
All right.
Right, thank you.
Okay, are you here on Armijo as well, Mr. Downs?
Yes, sir, and same exact situation. I'll let you call that.
You bet. So there's two cases here. So this is 26T 150 and 26M 124. Michael Benito Armijo, Mr. Downs representing on both cases.
Yes, sir. Your Honor,
these are appearances. So what do you think? You need some time to meet with your client, probably, I'd imagine.
Please, Your Honor, I'd ask for the same date and time that we just set Mr. Morgan for, please.
8/19 at 2?
Yes, sir.
Stacy, we got that? That was easy.
That was easy.
What else do we have for you today, Mr. Downs? I think that's it.
Your Honor, thank you so much, and my thanks to Ms. Garcia and Mr. Chow.
Yeah, appreciate your efficiency, and we'll see you next week for Mr. Ryan.
Sounds great, Your Honor. How's everything going, sir?
I can't complain about a thing. I appreciate.
He told me he goes around telling people he's a sheriff, and he even has like a funny costume, like a police costume. And he goes around legitimately telling people he's a cop. And she said, we're not related to Frank Azar. We are not related to Sam Consilia. Right. I thought it was odd. I normally I'm used to hearing Joe, but he said Sam. I had to Google it.
Maybe that's why I took sticks. I didn't know who that was.
Right. But she said that he relapsed and now he's just like swirling the drain. He's living in his car in his parents' driveway. He's kind of lost.
Yeah.
He had a bloody wound, like you could see he had picked his ear. It was actively bleeding while I was talking to him. Like his earlobe, and he had some other weird scratches and stuff. He's just not doing well.
He told Angel, he was like, tell Mr. Hill and somebody else on another name. She said, tell him I said hi.
Jeffrey Hill?
He said Mr. Hill. She said, I don't know who you're talking about. We don't have anybody by that name. And she's like, you don't know who I'm talking about. Yeah, okay.
You know. I know. Well, anywho, so he's, I don't know. I'm glad that I thought it was a better idea for him to get an attorney. Maybe James can help us get that done.
Maybe.
21.
Well, I'm glad I have 2 more.
Yeah, and I'm glad that he went to the public defender's office. He may have been confused, but that was a critical piece of the puzzle. I feel bad about that DeMello case getting continued. It's kind of my fault. Mr. Solis seemed displeased.
Hello. Hello.
Morning. Who do I have on the line?
I'm sorry, you speak Spanish?
Oh, okay. We're waiting for an interpreter, okay?
All right, thank you.
¿Cómo se llama?
Albert José Hernández Chavarría.
Thank you.